how is attorneys running up their fees if they know they're under a fee-shifting statute and have a winning case?
I think that's always the fear, and I think many of my clients believe that for sure. I have found that depending on who you're dealing with, it's part of negotiations. It's part of the tools in their toolkit that they're going to try to apply pressure to our side. Running up fees, I don't really want to go there and accuse anyone of that. Most of the attorneys I deal with, I think, try and be reasonable, they know they're going to have to ultimately defend those. And look, if you put yourself in their position, if you're negotiating a settlement and you say, well, I've incurred X amount of fees and that just seems completely out of whack, well, that's not going to inure any real goodwill towards the other side to negotiate further. So again, it's a balancing act. My overall answer to that question would be not really.
Do judges go to the point of looking at attorney timesheets in fee cases, or do they not go that deep?
Sure. Yeah, I touched on this a little bit in my presentation. I would say that if you find a very thorough federal judge predominantly, you will see line by line kind of breaking down each attorney, each amount, maybe not every single entry, but they'll look at the total amount that, attorney John Doe or Jane Doe incurred, and they will look at it for reasonableness. They'll look at it for the time incurred. That would be one end of the spectrum. I think probably about the same when they're looking at a fee petition, aren't real crazy about going to an extreme level of detail. So it's a little bit simpler to just say, I think things are a little bit excessive here. I'm going to knock it off by 10, 15%. You will see that type of opinion issued as well. So some do go to the level of detail you asked about, David. I would say it's the minority of judges.
For Peter Roach, does the FDCPA apply to a mortgagor who did not sign the mortgage note?
That's a good question. The FDCPA talks about debtors. A mortgagor who does not sign the mortgage is not a debtor. The mortgagor who signed the mortgage is the debtor. So the notices, you have to be very careful because the mortgagor is not someone who owes the money. You can't collect the debt from the mortgagor. You can only enforce the mortgage against them. A very interesting case that just came down a week or two ago, Carbone against Caliber, which discusses whether the FDCPA applies at all to foreclosures. And to the extent that a foreclosure is a collection of a debt, it does. To the extent that a foreclosure is not a collection of a debt, but is an enforcement of a mortgage, it does not. So my advice is assume that it does apply to you. It doesn't apply to mortgagors, but if you're supposed to give an FDCPA notice, I always figure it's better to give the notice and not have to than have someone rule the other way. So technically the answer is no, it does not apply to mortgagors, but always better to err on the side of caution.